This is episode 73 with Howard Green, Ted Augustinos, and David Burson.
Welcome to Spot On Insurance. Join us each week as we speak to insurance professionals, attorneys, regulators, and compliance specialists on topics ranging from improving your agency to staying on the right side of the law. Subscribe and stay informed on the effects of new trends and disruptive emerging technologies on your businesses and your industry.
Hi, I'm Ted Tavares.
And I'm Arlene Tavares.
Today we have a panel of guests beginning with Howard Green. He is the Director of Strategic Initiatives at ELANY. Howard is a government relations and regulatory attorney with expertise in proactively developing and managing national advocacy programs, drafting legislation, leading successful lobbying efforts, and promoting client interests with regulators. He leads various ELANY projects and services, including efforts to assist E&S brokers comply with the New York Department of Financial Services Cybersecurity regulation. Next is Ted Augustinos. He is a partner of Locke Lord LLP, an international law firm in the US, UK, and Asia. He serves as a member of the steering committee of the firm's Privacy and Cybersecurity Group and leads the group's incident response team and its New York DFS Cybersecurity Initiative. Ted is also managing partner of the firm's Heart for All. Ted has counseled clients in numerous industries, including financial services, healthcare, insurance, defense, retail, public utilities, professional services, and education. He advises business enterprises ranging from global corporations to small startups and nonprofit organizations, including large national organizations and small local charities, on their privacy and data security obligations. Ted provides advice on collection, use, and sharing of information and breach preparedness and response. He is a graduate of St. Lawrence University and Boston University School of Law. Ted is a guest lecturer in the Boston College Master's Program in Cybersecurity Policy and Governance, and former adjunct faculty member of the University of Connecticut School of Law. In other words, he's a heavy hitter. He's a certified information privacy professional, accredited by the International Association of Privacy Professionals. According to the Chambers USA 2018 listings, Ted is a recognized practitioner for privacy and data security nationwide. Then there's David Ferguson. He is currently the COO of RSI, Renaissance Systems, Inc. He manages all directors and professional services departments, developers, data science, IT, and compliance, with P&L responsibilities and personnel management. David has over 25 years in technology with experience primarily focused on consulting, designing, and deploying complex internetworking solutions, implementing business process improvements, disaster recovery scenarios, and business continuance strategies across all industries. He has held leadership and senior management roles with several companies, including Global Data Systems, a large communications integrator, Time Warner Cable, and most recently as strategic partner manager for Microcorp. David is a graduate of University of Houston Entrepreneurship and Innovation, Finance, and Marketing. At age 17, David joined the United States Marine Corps and is a veteran of Desert Storm. David, thank you for your service and welcome all of you to Spot On Insurance.
Thank you.
Thank you for having us.
All right. I would like each of you to start by sharing a little bit about you. Tell me your story. What's motivated you to follow the path that's now led you basically to Spot On? Howard, let's start with you.
Well, good afternoon, Ted. Well, I was born of poor but dishonest parents. But after that, I ended up going to law school and decided while in law school that I wanted to do government relations work. I was interested in political aspect. And my first job happened to be with an insurance association, Property Casualty Insurance Association, which was just a coincidence. It could have been anything. And that sort of led me into the insurance industry and piqued my interest in the insurance industry. I have spent my career on both sides of the industry, property casualty and life insurance. I've not been on the health side, and eventually made my way here to ELANY, which is even a little different, being on the excess and surplus lines side of things. And that's what's led me to Spot On Insurance.
All right. So, Ted?
Sure. And thank you for inviting me to participate, and welcome everyone. I grew up as a lawyer doing M&A and regulatory work for banks and insurance companies for the most part, and also producers. And at the risk of dating myself, way back when they first started having to think about getting out privacy notices and dealing with privacy and cybersecurity related issues, they turned to me as their regulatory counsel because they viewed this at that point as a regulatory issue. So I sort of followed our clients into this space. We were an early entrant in this kind of practice, and it's just been a very exciting sort of development and stage of my career. As I tell our team, this is the cool kids table.
David, what's your story?
Well, thanks for having me. My story is that, unlike Howard, I was not born of poor and dishonest parents. I was born at a very early age. Started my career where my father left off. My father was an executive of IBM for many, many years, 30-something years plus. He retired. When I got out of the service, I started college and got an opportunity to take on the networks for a massive nationwide company. And that's the way I paid for my school. And as a result, I stayed in technology my entire career, first as an engineer, then as a manager. But I was one of those that was able to communicate between the geeks and the non-geeks and the decision makers. And as a result, I moved more and more into leadership position and less into engineering. Because of our experiences here, especially here in Texas and the South with the hurricanes and especially in the last 10 to 12 years, started with Katrina. Even then, there were a couple there, like Lily, and then Ike, Irma. I mean, it just kept going on. And of course, last year, Hurricane Harvey, and then Superstorm Sandy that hit in the Northeast. I was very involved with many of the disaster recovery technologies, and I got to actually see the networks and the systems I'd implemented for my clients in action. And believe it or not, it was actually working, which was great. And so the summation of all my experiences have led me to Renaissance Systems. This is where I've met Howard and ELANY, found out about them, to take over this company, to see what is out there, what the next generation of compliance looks like, what does the next generation of data scientists look like, and compliance officers. And as a result, we have totally transformed our business to be more of a compliance-based IT services company versus just doing IT for the sake of doing IT. And this is what led me to here and to Spot On Insurance.
So you got the geek speak down pat then, right? You're going to really be able to help us?
Yeah, geek speak down pat, except for legal language. That's right. You have to use my attorney.
Oh, wait, that's what Howard's here for? Howard, you're going to take that legal side?
That's what Howard's for.
I have no idea. Ted and I will do what we can.
Yeah, we'll bring in the comic relief. How's that?
Good idea.
So guys, we bring this episode to you today, and it is a collaboration between ELANY and Spot On Insurance. The purpose of this episode and all SOI episodes are to discuss regulatory updates, current industry issues, and emerging innovations impacting insurance professionals. And just so if there's anybody out there that's unfamiliar with ELANY, ELANY is the Excess Line Association of New York. And as the name implies, it deals with the excess or surplus lines brokers licensed in New York, either as residents or non-residents. Therefore, we're going to be diving into this upcoming cybersecurity compliance requirement as it applies to excess and surplus lines brokers. Howard, if you will give us an overview of where we've been and what needs to be done next.
Certainly. Well, thank you very much, Arlene. First, let me start by saying that it's ELANY's pleasure to partner with Spot On Insurance on this program to bring insurance brokers the podcast on the upcoming New York Department of Financial Services cybersecurity regulation compliance deadline. So let me start by just briefly reviewing where we've been on the regulation and then what's next, which is the topic of this podcast. First, for those who do not recall the regulation, the New York Department of Financial Services Cybersecurity Reg, it became effective on March 1st of 2017. The regulation applies, and this is very important, to all New York licensed insurance brokers and firms. It applies to others as well, but let's focus on brokers and their firms. It applies to both resident and non-resident licensees, large and small, admitted and excess and surplus lines market. Anyone who's licensed as an insurance broker or their firm is a covered entity under the regulation. The reg includes multiple deadlines for the various requirements in the regulation. So what they did is they spaced out the compliance deadlines. Several of those deadlines have already passed. Some licensees have filed a limited exemption with the Department of Financial Services, which exempts them from certain requirements of the regulation. And so it's very important to know when you look at the regulation, did I take a limited exemption? Which limited exemption did I take? Or did I not take a limited exemption and the whole thing applies to me? Past deadlines included many important requirements that apply to everyone who's a covered entity under the regulation, but some of the requirements applied only to non-exempt licensees. So it depended, again, did you have an exemption, or do you have an exemption or not? The first annual compliance certification was due to the Department of Financial Services this past February 15th. That's February 15th of 2018. That's an annual requirement in which you have to certify compliance with the department. And we'll get to that in a moment. So the next set of requirements coming up, they have to be complied with by September 3rd of 2018, so just in several weeks from now. You have to comply with these requirements if they apply to you in order to certify compliance in 2019. And what that means is that in between January 1st of 2019 and February 15th of 2019. January 1st is the first date you can do it. February 15th is the latest you can certify. You have to file online with the Department of Financial Services, as you did in 2018, saying, okay, I'm in compliance with everything that was due that I needed to be in compliance with through the end of 2018. So these September 3rd, 2018 requirements, which are the focus of this podcast, you need to comply with them in order to certify next year. It's important to note, I think, that the only September 3rd, 2018 requirement that applies to licensees that filed a limited exemption notice with the DFS is Section 500.13, which is limitations on data retention. We'll be learning more about that from our guests shortly. But if you have filed for a limited exemption, that's the only thing that we're talking about that you need to comply with of the September 3rd deliverables. Again, Section 500.13, limitations on data retention. So today we'll be discussing 5 requirements. Those are the ones that are due on September 3rd, and they are audit trail. So if you get the regulation in front of you, you'll see that's Section 500.06. Application security, that's Section 500.08. Limitations on data retention, which we just discussed, Section 500.13. Training and monitoring, but specifically subsection 500.14A. So it's Section 500.14, but subsection A. And we're just talking about here the monitoring of systems access that's due as part of the 9.3 requirements. The training part was due earlier this year. And the final requirement is the encryption of non-public information, and that's Section 500.15. I do want to note here that we will not be discussing the third-party service provider requirements, which is Section 500.11, since the compliance deadline for those requirements is not until March 1st of 2019. That's the latest and the final initial compliance date. That's what we'll be discussing. I did want to mention one last thing before we get into the nitty-gritty, which is from the standpoint of ELANY, we invite you to follow us on LinkedIn to keep up with the news and events impacting the excess and surplus lines market. All you need to do is go on LinkedIn and search for Excess Line Association of New York and hit follow.
Wonderful overview, Howard. Thank you so much. And again, the reason that we're covering this in such details is because there's been so much interest in it, and it's something that impacts so many people across the United States because as we know, we have many, many people that hold non-resident broker licenses in New York. So we're going to jump into Section 500.06, and that is the audit trail section. Ted, if you can talk to us about what Section 500.06 requires.
Sure, happy to. So this section titled Audit Trail, like many of the other sections of the regulation, is required to be based on the periodic risk assessment that was required under Section 9, which is one of the requirements that became effective in March of this year. So you should have already done a risk assessment, and the risk assessment will feed into a lot of these requirements and most of the others under the regulation. but specifically the audit trail requirement of Section 6 obligates covered entities to securely maintain systems designed to do two things. One is to reconstruct material financial transactions sufficient to support normal operations and obligations of the covered entity. And the second thing is to include audit trails designed to detect and respond to cybersecurity events that have a reasonable likelihood of materially harming any material part of the normal operations. So what does this mean? This section addresses the DFS interest in protecting the business of the covered entity and by extension the financial services industry. It's really not focused on protecting the data of consumers, which is what we're sort of more used to in the US in terms of cybersecurity requirements. That's really where the attention has been, is protecting the data of individuals, personal information, protected health information, and others. This is really about protecting the entity itself. So it requires that you have an audit trail to reconstruct material financial transactions in order to be able to continue and support normal operations and obligations of the covered entity, so that the business doesn't fail in the event of a cyber attack or other cybersecurity event, and also to detect and respond to cybersecurity events that have a reasonable likelihood of materially harming a material part, again, of the normal operations of the covered entity.
Exactly what satisfies the sufficient to support normal operations requirement?
Well, it's clear that, those words mean that you don't have to be able to reconstruct every transaction and function, but only material transactions sufficient to support normal operations and obligations. So in its risk assessment, the covered entity must look at the types of transactions needed to support its normal operations and transactions and decide which of these are material. Let me give you an example. Your website may not be very important at all, depending on your business. For other businesses, it may be the way you do business. So in your risk assessment, you would look at things like your website and assess the risk that an attack on your website would pose to your ability to conduct normal operations. And based, again, on the risk assessment, you'd need to make sure that you had systems in place to be able to reconstruct transactions, material financial transactions through your website. That's just one example, but just to try and put some meaning around those words.
All right, let's get deep into how does a broker create an audit trail designed to detect and maybe even respond to cybersecurity events? How about David?
To answer that, I'm going to go ahead and start with this caveat that all businesses are not equal. Some are further mature in their cybersecurity plan. Some are further mature in their disaster recovery plan. And what I mean by that is that some companies take the philosophy that all data is important, whether it's under regulations or not. And so depending on the company, some may hold their accounting systems in very high regard and very high sensitive data, right? Though it may not necessarily be in regulations because their accounting system is so bland. It may just only have the name of their customers and hardly anything else. In other companies, they may be very, very lackadaisical, saying only those things that are under requirement will we be in compliance with. Okay, so not all two companies are the same, but a simple answer is to create an audit trail. You can enable your systems to track and maintain all data related to financial transactions. So in case of a breach, as a company, you have the ability to detect an event and then mitigate the threat via an audit trail. So in other words, there are systems in place with many software that you may have that says, hey, I want a log, event logs. There are others that are much more sophisticated that will track every single thing. In the technical world, you could have a server, which I call a radius server, or my colleagues would call a radius server, where you can see every single person logging in and logging out of anything that you want to track. Okay, so that's part of the audit trail. We were talking about the ability to reconstruct financial transactions. Having these audit trails, the timestamps, will enable you to not only reconstruct faster, but you could also see that the information was verified and validated. And usually that is through third-party software and guys who specialize in it. I'm not going to go into logos or people who I endorse here because, again, no two companies are really alike. But there are many applications in place now. One of the things that are going to gain traction is a thing called blockchain. And I think people are starting to understand it. And blockchain is where you got to validate the information of the previous person or the person that passed information to you. And there's a unique code. And that person has to, not only is that code have to be validated by the new person receiving that information, but it's got to be validated by the person that they are sending the information to, or the next person in the chain that's receiving that information. So I suspect this technology is going to mature greatly, but there are numerous amounts of ways or methods of doing this and still being in compliant. But creating the audit trail itself is going to require some software. It's going to require some planning, and if all else fails, engaging your CISO or your Chief Information Security Officer to come up with a plan and developing it is always a good place to start.
And I know that, like, you first started out, David, by saying that, no two companies are created equal. But can you give us examples of different companies? And, subsection B contains all of the requirements regarding record retention. How would it be vastly differ for two companies on how long they have to keep their records and how best they should organize those records?
Great question. So IRS requires 7 years, right? And then there's some other companies that may have an internal policy of 10 years. What I have found is that, like I said, implementing an audit trail system, whether it's enabling the logging within your business in relevant systems or using a third-party software, doesn't matter if as long as it's in good compliance and it works for them. And not only that, it's going to meet the needs of the client in a disaster recovery scenario. I find that saving data in digital format on encrypted file servers is more accessible, simpler to manage, easier to protect, and easier to verify who has obtained access to those documents. Another technology that is gaining traction in the insurance industry is called data classification. So when you're storing it, you could, for example, classify it under different categories like non-public information. You could also store it by criticality or sensitivity, based on trade secret, personal information, etc. So you can do this classification, and it's fairly slick using the database from it and makes it easy to search for the document as well. Lastly, again, you're going to have to define the important systems events that need to be logged for you. And some considerations, are systems administrators. Okay, what happens if that person leaves, or employees? You're going to want to see changes to any sort of financials or data, or at least have that ability. So when an audit is performed, you guys can track every aspect of a transaction. And also at the same time, monitor the changes to any system. Was there an iOS update, or did we have add additional CPUs, hard drives, or add additional software or revisions even? So those are the kind of considerations I would take on it. But pre-planning is going to be key to putting all of this together.
I want to go back to one of the things that we first started talking about in this section, which is the sufficient to support normal operations, and just kind of thinking about it from a broker standpoint. So, Ted, you mentioned the websites. So 2 different scenarios here. If you have a broker that's just kind of has a website that's describing the products that they cover on their website, perhaps, your website could go down and you could say, that's, we're still operating normally. But if you're a broker that's putting out there the certificates of insurance for your insureds, that's definitely detrimental to your business and to the people that you're providing a service to, because perhaps they cannot go on with their business if they can't pull those certificates of insurance, which they have always reached out to your website to obtain those certificates. So that's a very different way of using those websites. And I know a lot of brokers have, gateways where their clients log in. So that's something that they would really need to scrutinize how they're using that website, because if it's down, that's definitely going to bring down their normal operations.
Yeah, that's right. This is Ted. And just to offer another example, some use website-based portals to handle claims. I would think that would be a material part of the normal operations. And if that was disrupted, that would be a problem. So you'd need to be able to reconstruct, the activities through that kind of facility. And as you mentioned, there are others who, if their website went down, it might take them a while to notice. It's just not part of the business.
So let's move on to section 500.08, which is application security.
Ted, tell us about this section of the reg.
Sure. So Section 8 of the regulation is related to the security of applications that a covered entity might use, and it requires written procedures, guidelines, and standards to ensure the use of secure development of in-house apps. So if you're developing apps in-house, you've got to have written procedures, guidelines, and standards to make sure that they are secure. and securely developed. If you're buying apps externally developed, so you're using a consultant or some other firm to provide the apps that you use in your business, then you've got to have procedures for evaluating, assessing, or testing the security of those apps. And these procedures, guidelines, and standards have to be reviewed periodically and assessed and updated periodically by the CISO.
Isn't this something that if you have an external service that you've contracted to do this kind of stuff, wouldn't this be automatically done by them and all you'd have to do is make sure that that is getting done in order to comply with this reg?
Well, you might hope so, but we've got to be a little bit more cynical than that. So again, app developers aren't created equal either. So let's keep that in mind. If you're buying these kinds of services from a world leader, it would be a different process, I think, for satisfying the requirements of Section 8 than if you are using a startup or doing things internally. So I think your policies and procedures and standards have to identify these differences and account for them. So again, just to give an example, you might say that if you're using, certain kinds of companies with prominence in the industry, good reputation, willing to give you, representations and warranties about security, or otherwise satisfy you that they're developing applications that, have cybersecurity baked into their development, that may be a different process and a much more truncated process than if you're working with something that's bespoke, startup firm, or in-house, in which case you may need to get much more involved. And so, again, in thinking about what's appropriate for the particular covered entity, you've got to think about who you're dealing with and what your capability is of assessing these things.
Okay.
So you might end with some simple representations by a well-known entity. You might have to get more involved in making sure that things are secured if they're homegrown, or otherwise you can't really, satisfy yourself that security is sort of baked into the process.
David, maybe this will be redundant, but what might the procedures for evaluating, accessing, or testing the security of third-party apps look like from your perspective?
Well, from my perspective, I would say starting with your CISO, consultants, and compliance auditors are often good places to start, just because they have already identified vendors that are qualified and those vendors who have already met stringent security and company feasibility requirements. In the case of RSI, I have a CISO. I have hired a CISO. He starts here very shortly, just because I want to be in compliance myself in the part of the supply chain or the vendor chain of the brokers. So if they're going to be audited, then I can be audited. I can be held to the same standards, and we can be, work on the next initiative, because it's just a standard practice of what we're doing is that we're following the same standards as they are.
Mhm.
So starting with the CISOs and consultants and compliance auditors are often where I start personally, because like I said, they have already identified the vendors, I'm going to say the market leaders of their respective services. And not only that, they have, passed the smell test, right, of are they going to be in business for a while. It's not any good for folks like me to implement a company that's going to be out in business in 36 months, or it's a surprise they've shut their doors. Okay. I am not in that business at all. And part of the security requirements or auditing requirements for this NYDFS is that business continuance, right? We keep talking about the ability to continue business. Well, if I can't continue business because someone went out of business, especially with my vendors, I'm not going to look good, neither is the client. When evaluating or assessing a security solution from a third party, I always define the requirements and standards that the client wants to use. Okay, in this case, NYDFS, but we also have several others. Several years ago, it was Sarbanes, and then the HIPAA. But what are they wanting to really accomplish, and what are the requirements standards do they want to use? From there, we will identify who the possible vendors, providers are going to be. And then we're also going to request a SOC 1 or SOC 2 reports from them, depending on which one is more applicable. I'm also going to ask where the vendor's equipment is located. Is it out of their garage? Or is it, or do they have a fancy website with a bunch of pictures on it, but it's not really represent where the equipment is at in a, tier 4, tier 3 type data center? I'm also going to request their own DR strategy and plan. What does that look like? If they tell me, well, we got to develop it, or give me a month, I'm probably going to be very hesitant to work with them. Okay. And then I'm also going to ask for a list of references. And I'm also going to ask some serious questions as tell me about your biggest jackwagon install, or what happened. Tell me about the worst mistake you guys ever made as a company and how did you mitigate it? I'm asking them some about their good successes. So as we identify these things, it gets easier and easier. But again, CISOs, consultants, and compliance auditors, they have the experience. They seem to have an awful lot of visibility as what's going on. And they can also identify the needs faster than even though sometimes the clients can. So that's where I start. And again, no two companies are going to take it the same approach, but at least that's the way RSI does it here.
Spot On is sponsored by Insurance Licensing Services of America. Need help with corporate name changes, annual returns, or surplus lines tax filings? Feeling overwhelmed? If you're looking for experts in regulatory compliance, you've come to the right place. ILSA provides the industry with over 50 services. To learn more about the company and how they can help, visit ilsainc.com.
Ted, how often should procedures be reviewed? Because the regulation just says periodically.
Right. The regulation's silent, and it uses periodically in a number of places, but it's silent on this point, and there's no published guidance at this point. So you'll want to define periodically in your written cybersecurity program and related policies based on your risk assessment. I think that, based on talking with our clients and colleagues, including colleagues at other firms who track this all closely and advise clients in this space, I think most people would say you're pushing it if it's longer than a year, for most companies anyway. I think the point to periodically is that you've got to keep up with changes in threats, defensive techniques and technology, changes in personnel, changes in business operations, all of which change very rapidly. So I think, again, depending on your risk assessment, your written policies and procedures ought to be defining that things will be done, no less frequently than, depending on the organization. Again, not all are created equal. Annually, every 6 months, every few days. We've got one client that literally reprioritizes its threat assessment every day.
Wow.
That's an extreme.
But the standard is the one that you set for your company based on your needs and what you see as possible issues. So if you put 3 months, then that's going to be your standard, and that's what they're going to look at.
Two things on that point. One is, let's pick your 3-month example, or, plug it a year. First of all, you better live up to it, right? Don't say you're going to do it annually and you don't do it.
Exactly.
And second, you better be able to defend it. And by defend it, I think it's got to, again, point to your risk assessment and also document that you've made a thoughtful determination based on your resources and based on your assessment of the related risk. So here, if we're talking about security of applications, and your applications may not be very critical, they may not be tied to systems. I mean, there are different reasons to look at this differently for different companies. So just document that and then, again, abide by it.
All right, let's move on to 500.13, limitations on data retention. Ted, can you give us an overview of this section?
Sure. This is really about and we kind of touched on this a little bit in the audit trail, although that's a different requirement because that's really, again, related to the functionality of systems and the ability to recreate transactions. This is really talking about the risk related to keeping around old data or disposing of it improperly. So to just kind of, highlight the issue here, we worked on a breach once where a financial institution had to notify 1.2 million affected individuals, about 2/3 of whom were former customers. So if they by their own estimation, if they had gotten rid of the data they really didn't need, it would have been a couple 100,000 individuals. So imagine, your customers don't like getting breach notices, but imagine the recipient who's wondering why you still have their data after they terminated the relationship, in some cases many years earlier. So to mitigate this risk, covered entities are required to have policies and procedures for secure disposal of non-public information on a periodic basis if the data is no longer necessary for the business. Obviously, there's an exception if you're required by law or regulation to retain the data, but you start by looking at how long do you really need it for your business, including for existing customers. This isn't just about, dead files. And then you want to obviously look at data retention requirements by law or regulation, or if there's a court order or litigation hold, those kinds of things. And then you want to kind of start building a time frame on which you're going to get rid of data you don't need. There's also an exception where the targeted disposal isn't feasible due to the manner in which the information is retained. And I think that's technical enough that I think David's going to talk about that in a bit. But it's important to note that this requirement doesn't apply to retention of business information that's not personal information. So this particular section of the regulation talks about non-public information under two of the three subsections that define non-public information. So it really has to do with information about individuals, what's typically referred to as personal information or health or medical information. So if you think about that universe of data, what you've got to do here is build, protocols around getting rid of it when you don't need it. Again, with the exceptions of legal and regulatory and other reasons to retain it after you don't need it for your business anymore. And the other thing I'll add is that, as you're deploying new technologies, it's important to design data mapping and disposal into your facilities, because this can be very expensive and difficult, or it can be very easy, depending on how your systems are set up. Unfortunately, most covered entities are working on systems that weren't really set up with this specifically in mind. So it's cumbersome, it's expensive. Again, you've got to, I think, do what's right for your business.
That was a really good point that you mentioned, Ted, on, that one entity where they had a breach of 1 million or so and 2/3 were ex-clients. That's a reminder for all to purge that data, or, at least put it somewhere where it's not as accessible as your current client's information. And right there, you're kind of, separating that liability as well. David, I just want to ask you now, we're talking about disposing this data. What counts as secure disposal of data?
Well, secure disposal of data, it just actually means is that it's gone, right? Erase it, take it away. I mean, that's how we define it. We've had some customers who said, get it out of our data center. They want the hard drive. They will certify that it's been decommissioned. Okay, those hard drives have been decommissioned. Other clients of ours have asked us to decommission their servers and their hard drives and their RAM and everything else that goes along with it. And we use software, and we use software in some instances. Other instances, the client wants to see a physical hole go drilled into the hard drive.
Oh.
And us certifying that it is now non-functional. So it goes either way, but again, it can go through the software way, right? We use software. Like if my equipment, or if my software or my data is in a cloud and I do not own that equipment, I could easily deploy software onto the equipment of the data center just to make sure and ensure that all that data is gone. So it constitutes that you don't have to secure dispose of the data. Other times, if I'm owning the equipment and the client wants me to get rid of it and they physically want to say, I want to see that hole, and then my technicians and my engineers have certified that the data is no longer accessible, no longer there, we'll follow that method. So I've also seen it, believe it or not, that they said since we don't need this data anymore, we use it as target practice. So it goes either way. It goes many different forms, but as long as it's destroyed or people cannot access it and or written over, I think that's what's constituting what secure disposal is.
What's information that it may not be feasible to dispose of due to the manner in which it is obtained? What fits that category?
Well, so information that's stored with relevant, that may be part of relevant company data. Okay. So there's some data that the U.S. government may want to have. So let's say personal data, right? Mm-hmm. Of how many veterans or how many African Americans or whatever, how many had in the medical world, what percentage had this this disease were treated. That's very useful information. And that may not be data that they want to get rid of, right? Because researchers may be using it. So that may be infeasible for us to get rid of that, okay? Data that resides on employee devices is always, at risk of not being attainable, especially if they are called former employees, right?
Yes.
Terminated employees. Those are hard to get, and especially if they're being extremely uncooperative. But lastly, there's this thing called big data analytics now, or data analytics, and where people are going back years and years of data, having code running through these databases, and they're using it. You're using that information to provide research information to whatever entity, university, science, federal government, whatnot, or they're using it for themselves to add value to the services offered by the company. And that data may not be feasible to destroy just because there are so many other programs running on it and they're trying to extract additional information from it. And big data analytics continues to grow. And I've seen information where they want to, data or stats going back 25, 30 years. What did the population look like for a certain region? What was the demographics? Why is it changing? Why are, are we seeing more cases of certain disease or certain mutations that we hadn't seen before?
Yeah, got it.
So this is why. So that's kind of information you're not going to be able to easily say this is destroyable, and especially if it's research or some other government entity would like for you to perform research on it, and going back years and years of data.
Okay, well, guys, I don't know if it's my love of espionage, but I feel like I kind of stumbled upon a little dark secret, and maybe it's just picking up stuff that's really not there. But David, you mentioned something like, we could use this data for target practice. What does that mean?
Oh, well, so, okay, so so we did C format, okay, and got rid of the data.
Uh-huh.
But just to make sure, I took a group of executives on a dove hunting trip.
Yes.
And then a few months later, I took them on a deer hunting trip.
Yeah.
Here in Texas. And as a gift, I put the hard drives as target practice as we're sighting our rifles in before we went deer hunting.
Okay, so it's like real target practice, like what we do in Texas. Okay, like I thought it was like some dark secret, some like tech speak. Like
no. The data had already been wiped out, but we had them in there because I didn't have the authorization to get rid of. I didn't have the authorization. My text didn't to throw them away or do what or to recycle them or whatever.
So you recycled.
So we kept them. So I brought them with me.
I got you.
You recycled in your own way.
Okay.
Yeah, so we brought them, and yeah.
I was reading something way out there. Okay, cool. So, Ted, let's jump into section 500.14, 14A, training and monitoring. Talk to us a little bit about what this section covers.
Sure. Basically, as part of the cybersecurity program, the covered entity or licensee has to have policies, procedures, and controls in place to both monitor the activity of authorized information system users and detect unauthorized access or tampering with non-public information by authorized users. So let's take a step back here. The section has two subsections, A and B. B is the subsection that required cybersecurity awareness training for all personnel and is already effective. So presumably everybody on the call has already done that part. But in September, you'll need to comply with subsection A, which requires the covered entity to implement risk-based policies, procedures, and controls designed to monitor the activity of authorized users. So this isn't about protecting against intruders like a traditional, sort of data breach that we normally think about. This is about making sure that people internally are misusing or tampering with data. So you've got to have systems in place to make sure that you would know, again, it's based on your risk assessment, but you've got to have some level of control that would reveal whether employees and other authorized users may be improperly accessing, using, or tampering with data.
Okay.
Some companies are very sophisticated, even predictive in these controls. And, David will talk more about the technology, but it can be very fancy and really impressive in terms of the kinds of controls that are available, again, even predictive. So anticipating when somebody might go off the reservation, but you've got to have something, again, appropriate to your company and your risk assessment that would identify people who are stealing or improperly accessing or using data.
Okay. David, step up to the mic and tell me what kind of policies, procedures, and controls can a broker reasonably implement to accomplish this requirement?
Well, so security policy development can get extremely political. It can get extremely complicated. But in actuality, our policy has always been is intrusion prevention and intrusion detection. So predictive analysis, what happens when an event occurs. We can sit here all day and all year trying to figure out every single event that can happen. But basically, who is accessing data and why? So we will put security policies in place at the HR level. That's the first thing. Here are the access this employee by their job function and role and title is able to get to. And that is validated by the CISO at the IT level. So the firewalls will be put in place. MAC addresses by their device will be blocked. For certain applications, static IP addresses will be used just so that we have data routing for the appropriate people. We will also implement and design the appropriate solutions. They're not very expensive. We're either going to insource it and do it in-house, or we can outsource it and look at the appropriate vendors. And again, we're going to go through the smell test. Are they, those vendors financially feasible? Do they have a good DR plan, et cetera? So we'll look at the firewalls. We'll look at intrusion detection, intrusion prevention. We will also evaluate the employees themselves and their roles. If I see the warehouse guy has access to the brokers, to non-public information of a client, I'm going to ask why, right? So doing an audit or an assessment, I'm not going to say an audit, doing some assessment, pre-assessment, just to gauge where you're at, right? And then we can start identifying there. Assessments are always a great place to start. We don't call them audits because audit is after something's been implemented, and now it's for compliance. It's for to see if there's policies and procedures being met. Assessment is just tell me where I'm at so you can tell us where you're going, right? And starting with that, the periodic review from your CISO to ensure appropriateness of the privileged admins. Some people look at it once a quarter. Some people look at it twice a year. Some people look at it every 12 months, depending on the size of the company and depending on the size of the turnover. One of the things that we're seeing trends with now is people with significant events in their lives or attitude behavioral changes. And again, there's no right or wrong answer on how they react to that and what even defined as attitude changes of an employee or somebody who's got administrative access or even access to data. But firewalls is the easy way, but there are numerous other tools and outsourced companies out there that can help you with identifying and assessing where you're at so they can put the right solutions in place for you, just so you can get into the policies, procedures, and controls in place. And it can get as complicated as you want, or you can get as super easy as you want. But at the end of the day, you're going to want to be in compliance. And at the end of the day, you want to take very reasonable measures to protect your information and those who can access it.
Those even sound like the standard of what most companies do nowadays. You have limited knowledge in certain areas and your password only allows you to go to a certain point.
Yeah, and logging is a big part of it. Logging and documentation, or being able to pull those reports automatically from your devices and your systems to see who got in and when. And the login requirement of 500.6 of the regulation will help keep track of changes made by administrators. And my big fear, this is a trend that I've personally seen, I think many of my colleagues will say the same thing, most of the data breaches is not from the third world, from Europe or Asia or Russia even. It's coming from internal employees.
Yes, we hear that all the time.
And this is where, again, what happened in this person's life? Did anyone notice attitude changes, behavioral changes that just doesn't fit with this person? Or, if the background check came up with red flags. So there's just all kinds of things. And sometimes, in Austin, Texas, the employment market is extraordinarily competitive. It's very, very low employment. We have more jobs than we have people to fill them. So people are hiring bodies for the sake of hiring bodies, I think, sometimes, without doing the due diligence. And I think sometimes companies are not taking the time to find the right people, or even with existing employees, to be really keen and aware of what's going on in their lives. Interpersonal relationships, to me, is the best preventive medicine.
Right. Look out for those red flags. So guys, we're going to jump into the last section that we are covering here in this episode, which is section 500.15, the encryption of non-public information. Ted, what does this section require?
So while Section 15 is titled encryption, the requirement is actually to implement controls, including but not limited to encryption, again, based on the risk assessment, to protect non-public information, both in flight or being transmitted over public networks and at rest. if encryption is determined to be infeasible for either data in flight or data at rest, then you can use alternative compensating controls that are reviewed and approved by the CISO. So this is important because many listeners may be familiar with the Massachusetts data security regulation, which was kind of a first of its kind, several years old now, required encryption of data in flight. But this is a new requirement for data at rest that most companies are not yet prepared to deal with. So data at rest would include, basically on your systems, behind your firewalls, on your desktop, in storage, those kinds of things, as opposed to data that's being transmitted by email, for example.
And there's some of you out there who might be asking what CISO is. You've come late to the party, haven't heard the word before. It's Chief Information Security Officer, CISO. David, what would make the encryption of non-public information in transit over external networks infeasible?
Well, this question I struggled with the most, just because encryption is really the way, whether the information is in flight or whether it's at rest. Encryption to us, it was a non-option. And there are numerous amount of software out there. One of the methods that you can do for encryption, for email, for data in flight or data in transit, is getting a service on top of your email. And there's numerous companies who do that, cloud providers that will work just fine over your Microsoft Exchange for your email and or the Office 365. There are other email clients that you can use that have the same sort of encryption. One doctor talking to another doctor over a patient. There are numerous ways of doing that. My company in particular has not looked at anything other than encryption, in particular 128-bit encryption, which is way beyond what the military uses or what the military uses and beyond, just because that is the most secure way of doing things. However, if companies have taken, and again, I don't want to put the words in the mouth of any CISO out there, and I don't want to play the role of a CISO because I am not one. I'm going to let them determine what constitutes non-encryptable data. And I don't want to give anybody ideas on this call or on this podcast about what it constitutes it, because I would like for them to use encryption as much as possible. And that to me is one of the most sure way of not being able to get into your data. All right, so I'm not so sure, again, the CISO's definition. My personal CISO gave me some ideas of what is not considered encryptable data, but I'm not so sure I'm comfortable speaking about that at this time.
Yeah, this is Ted. We've seen, I've not seen companies say it's infeasible to encrypt data in flight, so we're going to use these other alternative compensating controls. I suppose you could do things like make things, certain kinds of information available only through secure portals, so it's not actually being transmitted, but then it's not in flight. So I don't really know what that means either. Data at rest, we've had clients struggle with, for example, large volumes of backups, and just the feasibility of going back and encrypting old backups that aren't ready for secure disposal yet. It can be difficult and expensive, and so you can build, I think, alternative compensating controls around that kind of data by physically securing it, for example. So even though it's electronic data, it's on disks, and the disks are in Fort Knox, that kind of thing, I would think would be a possibility.
It does sound to me like blockchain is going to make a big difference as that comes in, because that's been showing so far to be a form of encryption that they haven't been able to break into.
Right, and that's a good point too. And going back to what Ted just said, the VPN connections. We use VPN as much as we can that are secure, okay, for non-encryptable data. It's, going back to, okay, we had a backup that failed, right? We got to redo this. So secure VPN connection is one way, I suppose, when it's in flight. But in another instance would be if two people need to share information, but they have two different types of applications. I mean, imagine in the healthcare industry how many different types of practice management systems there are for EMR, EHR records, right? In that case, you got to have a specific application to be able to encrypt it anyway. But we've struggled with this portion, and I'm not so sure what constitutes, because I don't have a single client right now who is not encrypting their data,
okay,
through VPN or not. Okay.
Okay, so guys, and Ted, in particular for you, the cybersecurity compliance requirement is applicable to all New York brokers, whether they are residents or non-residents. And I could see not just one, but many, especially non-residents, just saying, what the heck? I never even heard about this compliance requirement. What do you do if you're an agency principal and you're doing business across the United States and you are writing business in New York, and so, you're a large agency? What do you do if you're just hearing about this today?
Hurry. I think, look, you can't change the past. Most, in fact, of the requirements of the regulation are already effective. Several are coming up, including September and next March. The one next March, which was referenced earlier on third-party service providers, is for most covered entities the most onerous of the requirements. So it may be very difficult starting today to get into compliance, even going forward. But I think the point is that there's a section of the regulation, Section 20 on enforcement, that says this regulation will be enforced by the superintendent pursuant to and is not intended to limit the superintendent's authority under any applicable laws. So I think you're now talking about what will the enforcement profile be of the superintendent. I think that if you're a big high-profile company with lots of resources who should know better, just do the best you can, get into compliance and hope for the best, but you may see some action. If, you're somebody who's got a little bit of business in New York, technically covered, not really on your radar, you're making best efforts going forward, it's going to be enforced like any other regulation. Will they look for examples to make? I think so. But they probably won't look for cases that are very sympathetic to make examples of, I would expect. So not a lot out there on what to expect for enforcement, other than they are taking this very seriously. They're also understaffed, by the way, so you may have that going for you for the time being. But just do your best to get into compliance and document maybe why you didn't know about this or how it came to your attention and what you're doing, how hard you're working to get into compliance. And that's probably the best you can do. But, if it gives you any comfort, if you're one of those, you're in good company. There are lots of covered entities that really haven't paid sufficient attention to this yet.
Oh, wow. Ted, also with you, we had South Carolina that rolled out their cybersecurity regs a couple of months ago. And what are you seeing with the other states? Are you seeing things like this being developed and being thrown out there to the brokers?
Sure. So the NAIC had been working on a model law for a couple of years when New York sort of, jumped the gun and came out with its totally different approach, much more prescriptive, much more technical. The NAIC essentially scrapped their effort and adopted a probably more flexible, less precise version of the New York regulation as the NAIC model law. South Carolina was predictably the first state to actually enact it. I say predictably because the South Carolina superintendent commissioner was the head of the NAIC task force on cybersecurity. So he certainly wanted his state to be the first, but other states surely will follow. So I would say, as you're coming to compliance with New York, keep an eye out for the other coming requirements in other states based on the NAIC model. The NAIC model has a drafter's note that says that if you comply with New York, you're deemed to be in compliance with the NAIC model. So that's good for companies that are working hard at getting into compliance with this. You should not have to do anything different to comply with the NAIC, even though there is some daylight between the two in terms of what they require and of whom. The other thing I'll say is that California has come out with a very sweeping law that's not effective until 2020. It's widely predicted that there will be some amendments to that law, but keep an eye on that. It doesn't just apply to financial services. It will have broad application. It is more like the EU's GDPR, General Data Protection Regulation, in terms of its approach to privacy and security. It's not as precise and exacting as the New York DFS regulation, or for that matter, the NAIC model, but again, a different set of requirements. Basically, again, more flexible and based on reasonable security for the most part. So this is worth paying attention to and also following as it tracks through other states. Colorado and I think Vermont have adopted very close to the NAIC or the New York DFS regulation, but for the securities industry, which is accepted from the New York DFS regulation because securities is not regulated and licensed by the New York DFS. So we'll see lots of these kinds of efforts across the country. And I, just don't tell them I said so. Let's keep it between us. But I think the New York DFS actually did a pretty thoughtful job on this regulation.
All right. I wanted to ask David, the way technology is developing so rapidly, what opportunities are you seeing for insurance departments to protect the data that's being submitted to them right now?
So you're right. The technologies has changed, but I'm also seeing roles that have changed. The role of the CISO. Now there's role of the virtual CISO. So we're these smaller brokers that cannot afford a bigger or the payroll of a full-time CISO. They can rent a CISO, so to speak. I'm also seeing opportunities in the technology for cloud services where everything is as a service, where all the data, the users, things like that, virtual machines, virtual desktops such as like VMware, those kind of guys that are also having all the data at a data center, nice and secure, and it appears like all that information is on the local desktop or PC or whatever of a broker, but in reality, it's never stored on that local device. It's always back in the cloud data center. So I'm seeing that as a trend. The adoption in the insurance industry in particular has been very, very great for cloud providers or data centers, just because the capital expenses of buying new equipment and implementing, supporting all of that is now as a service, pay by user, pay by drink, pay by number of CPUs, et cetera.
Mm-hmm.
I'm also seeing opportunities here to further protect the data is that there are a lot more companies that are specializing in data protection and data restore. That's more in compliance with what New York has rolled out here. And going back to what was said previously, as the regulations change, I think you're going to see more and more companies on the technology side change to become more compliant themselves, just so they have that nice little certificate or that nice little compliance letter saying, hey, I'm compliant for this, which will help them more in sales. I'm not sure it's going to help the end customer or the brokers themselves become more compliant. At least it's a good start. There are some other changes I'm looking at or I'm reviewing now, not just on the compliance side, but on the consulting side, and the role of the CISO, where they are actually getting more and more involved in implementing the technologies. And sometimes they're very complex, sometimes they're very, very uncomplex, depending on the size of the organization and where they're already at. But I would say the role of the virtual CISO and cloud computing and cloud providers and the all-in-one providers just for insurance companies are some great opportunities for them to take advantage of.
It seems to me that would reduce the burden, though, on the brokers and what they have to do for cybersecurity if the cloud starts to take over in that way.
Yeah, absolutely. And I get brokers all the time that says, David, I'm in the insurance business. I'm not in the IT business. I'm not in the security business. This is all I want to do, and this is all I want my guys focusing on. And you're right. So they are outsourcing to managed service providers, and they are outsourcing to cloud providers to take that burden off and to also accelerate their time to compliance as well.
Okay. All right. We always like the professionals that we have on, like you guys, to talk to our circle of insurance professionals, especially those newbies. Give them some advice. What can you share with someone that's just entering the industry? They're preparing to take over the world, the insurance world. So what's your advice, Ted, legal and insurance perspective?
Sure. I just think that the collection and use of data and the opportunities that it presents to use data effectively to design and deliver products, but also the risks that are presented, the kinds of cybersecurity issues we've been talking about, are really part of the landscape and the environment. So if you're in sales or you're in operations or you're in finance, or really doesn't matter, this has got to be part of everyone's lexicon and thought process. We talked just briefly about app development. I mean, you can't have apps getting rolled out by the marketing team anymore. It's got to be, security's got to be, as I said, baked in. And that has to do with all parts of the organization and its operations. And so I would say if you're new to the industry, there's probably never been a more exciting time. And this whole area presents, challenges that, frankly, everyone is learning, exploring, and wrestling to deal with. So great opportunities out there for people who kind of keep their eyes open and keep themselves aware and up to date.
All right, thank you. David, how about you? Technical insurance.
Well, first and foremost, I'd say I have to agree that this is a great, exciting time to be in the insurance industry. But one of the things that I would advise anybody new coming into this is have a very good understanding of the compliance issues. Okay, you don't have to be an expert in it. That's what the attorneys are for, right? But also at the same time, have a comprehensive integrated security solution in place before. Understand what that is. Look at the components. If it's out of your league, get some professionals involved in it. Ask your colleagues. And I just also want to remind them that compliance and data security go hand in hand, and having a good data security practice often simplifies compliance and the associated audits that come after that. I also would recommend that they consider moving to the cloud because of the certifications that data centers already possesses, and also the simplicity of deploy and the reduction in cost and much better support at that. But I should always say, get your management team involved and develop a plan of action. Assess where you are and where you want to be. Plan and design a security compliance strategy. Identify technical hardware software requirements. Include people training. Implement the solution and manage it, whether it's you or somebody else. Make security and compliance a part of the culture and operations of your organization, and support the initiatives and evaluate 1 to 2 times per year with your CISO. So I think, it seems a lot, but doesn't have to be for the insurance folks out there. None of this is going to has to be complicated. It's just that, you're going to want a good plan. Implementing it's one thing, planning it's another. But that's something that you're going to want to seriously consider first, I think, embedding security and compliance together, because your operations will certainly support it.
Ted, it's Howard. Yeah, I wanted to add something which is on a more general basis on your question.
Yeah, I wasn't going to let you go.
Yeah. My advice, as they say in Animal House, my advice is to start drinking heavily. But aside from that, my advice for someone new to the industry is have as broad an experience as you can early in your career, meaning to the extent you can avoid it, don't get pigeonholed just doing one thing. If you're in an organization, do as much as you can in that organization, the breadth of what that organization does. Really learn how the business works. That's, to me, is makes you far more valuable. It's far more interesting and sets you up for learning and development in the future, which is going to be key to any career. And as part of that, and I think it's becoming in some ways a little bit of a lost art, is to the extent that you can do it, do some networking, get involved in some of the associations in the industry. Don't just sit there in your office, in your cubicle, doing one thing. Get out there, meet people, talk to them, hear about different experiences, get as broad an exposure to the business as you possibly can.
All right. Fantastic, guys. Thank you very much. Now, if some of these insurance professionals want to get in touch with you guys somehow, Ted, how do they get in touch with you?
Well, if you have the spelling of my name, I'm probably the most easily Googled guy on the planet. But certainly email, telephone, which I think are being provided to you. I can repeat them if you like. But, either way, happy to talk with anyone in the industry. And we can provide any guidance, happy to do that.
Okay. David?
Yeah, same thing with my email. I think you got my email. They could also call me personally. My number is 512-334-3345. One thing is we're never in the sales game here, at least on my side. I just want to have a conversation with you guys to see where you're at. I want to take the pain away from where you think you may be or where you may not be. Okay. I just want to be there as a friend and just kind of give you some advice on my side of what I've seen, because some of the things I've seen are not written in textbooks yet, but they will be.
Howard.
Well, I am fluent in smoke signal, but if you don't happen to have that at your disposal, you can either reach me by email at hgreen, green like the color green, but with an E at the end, at elany.org, or you can call me at 646-292-5591.
Thanks, Howard. Please don't forget to join us next week as we explore marketing and conversion-focused transformations through the power of LinkedIn and social selling with Josh B. Lee, the CEO of Standout Authority. Over the last decade, Joshua has managed north of $100 million in ad spending and controlled over 30 trillion online impressions. If you want to learn the art of marketing on LinkedIn, you can do it next week on episode 74 of Spot On Insurance. Guys, it's been a pleasure having you. I'm really glad ELANY agreed to utilize our podcast to help get the message out. I think it's information brokers really need at this time.
Absolutely. Thank you so much, guys, for joining us on Spot On Insurance.
Thank you so much.
Thank you. Terrific.
Visit spotoninsurance.com, where you'll discover an ever-growing library of podcasts, videos, articles, and online tools by professionals for professionals to enhance your insurance education. By the way, that's where you'll also find our podcast notes and bonus resources. Please don't forget to click the iTunes link to rate and review, and let others know what you think of Spot On Insurance. Thank you for joining us, and we'll catch you next week.